So we propose the following statement. Members of the jury, I'm going to tell you about a new piece of evidence. A viewer following the trial and familiar with finding archived website links investigated the link referenced on Defendant's Exhibit 102, Mr. Sanderson's email to his daughters on the day of the accident. Through the viewer's efforts and expertise, he provided a functional link to defendant on Friday. That was 2 days ago. Defendant immediately disclosed those documents to plaintiff in the court. And then this was the addition we just were thinking of adding. Plaintiff has since accessed the page through Terry Sanderson's MeetUp login. This link leads to, well, I guess that wouldn't be able to go right there, but that should be added somewhere. This link, the one that was provided by the person following the trial, leads to a meetup.com post made by Mr. Sanderson and the associated pages of comments, which includes comments made by plaintiff and Mr. Ramon about the accident unavailable to either party.
Previously unavailable.
Yes.
Well, so I don't like that last sentence.
Okay.
Because I think it was previously available to them.
Well, what I propose then is that you say, or that I say, that we're equally available to both sides.
I think that's accurate, Your Honor. There's a kind of continual insinuation that plaintiff hid something or withheld something that's already been in the fabric of this case, and that's the biggest issue for us on the plaintiff's side, is that we disclosed this, we disclosed these links, and whether they were explored or not, I think is moot at this point, because we've now discovered there's additional evidence that I think it should be neutral. I don't think
So why were they not equally available?
Because he reactivated his password just days ago and brought
That's
up...
not accurate, Your Honor.
I'd like to hear it from Mr. Owens. Go ahead, Mr. Owens.
In chambers, they said...
No, you don't need to repeat that. But why was it not equally available to both sides if this tech geek, for lack of a better word, was able to find it?
Because it required their password.
So this person that contacted defense counsel had their password?
Okay.
It seems like with computer forensics, either side could have accessed that link.
Your Honor, we tried 100 times to access
I realize that.
link.
I realize that, but it seems that it was equally available or equally unavailable to both sides. It was very difficult.
I think what happened is Terry reactivated his account a few days ago, and then the viewer was able then to access the...
And how do we know this? Do you have a computer expert that's going to say that?
Your Honor, if I may, that's the crux right there. There's no facts to back up that. That might be a defense theory, but besides just pure speculation and supposition, there's no computer expert that will say that somehow logging in under Mr. Sanderson's credentials reactivated anything.
Well, I think I've already identified that being the issue. But even if that were true, Mr. Owens, through discovery, you could have asked for that.
I did, in writing, and Deer Valley did. Give us all photos like that.
This isn't the time, though, to fight that battle.
We're dealing with something that came about Friday morning at 10:30 a.m. So it's simple for them. It wasn't simple for us.
Well, I'm not convinced that it was simple for them. I don't have facts before me to say that it was simple for them.
This is out because it came to us and we disclosed it.
Right.
To this day, they didn't get it. This idea that it's all equal, I don't agree, and I think they're going to argue, because they told me they would on Friday, that Mr. Owens in opening said this is the most important evidence, and look, here it is. And without some statement, like a viewer contacted Mr. Owens' office, my office, and we immediately disclosed it, then it looks like I've lied to the jury in opening, Your Honor, because it was equally available.
Why don't you show me what you can agree on, and maybe the availability comment just isn't part of the court's instruction. I just give them the facts that on Friday a viewer of this trial was, basically sent a copy of the document that they were able to obtain through Internet Archives and got it to the defense counsel, and the defense counsel then disclosed it to the court and to plaintiff's counsel. Mr. Sykes?
How about just saying it's just totally neutral? This has since been discovered. No one is at fault, but it's since been discovered. That way, you don't help anybody by the way you announce it.
Well, if you could give me that additional language that you believe that the two of you had agreed on, and I'll just look at it and I'll make a decision. I understand Mr. Owen's position that he doesn't want nobody's at fault, or it was equally available or equally unavailable. He doesn't want that language in there. I'll consider all of the proposals and give them an instruction.
And the defendant found it.
I think that's in the language. Not that you found it, but that someone sent it to you.
And we immediately disclosed it.
Yes. Yeah. Okay.
But that's trying to get some benefit from it. See, I'm saying that it should be neutral.
Well, I'll take that into account, and what I want to do is disclose to the jury the facts of what happened so that they can understand it. So there'll be some information about.
There's still
A viewer found it. It's been produced, and here it is. That's it. It doesn't have to be we immediately disclosed it, or somebody's at fault, nobody's at fault. The viewer found it. We have it. Here it is.
And Owens is saying it doesn't exist, but here it is. But it was Owens who just found it and disclosed it. So I didn't find it, but
I think we've
Okay.
got everything out that needs to get out on that issue. Well, there is a new piece of evidence in this case. I'm going to tell you about that. A viewer that's been following this trial out of the court and familiar with finding archived website links investigated the link referenced on Defendant's Exhibit 102. That's the Mr. Sanderson email to his daughters on the day of the accident. There's a link at the bottom of that page. Well, this viewer, through their efforts and expertise, through that, we now have a copy of what was the link. And you will receive it. It'll be an exhibit. It's Plaintiff's Exhibit 44 and Defendant's Exhibit 102. Plaintiff's Exhibit 44 and Defendant's Exhibit 102. And the parties do agree that this new exhibit is authentic. Plaintiff, you may proceed.
Thank you, Your Honor. Plaintiff Terry Sanderson recalls Craig Ramone.